courtroom, and we're also streaming on Zoom as well. Mr. Peterson, you are representing Ms. Perkins, is that correct?
Yes, I am, Your Honor.
And am I correct that your client is present on Zoom listening to these proceedings?
I believe so.
Thank you. All right. Mr. Hart, you ready to go?
Yes.
Okay. All right. I have received, now what I would like to do is to go through the record to make sure everybody has the same information that I have. And so let's walk through what I have reviewed in preparation of today's. There are a number of documents filed on 6/17, and that was the petition and an order. Let's take a look. Yep, order on motion for show cause. Then on 6/24, document number 4, sheriff's return on service. On 6/29, we have a notice of appearance by Mr. Peterson on behalf of the state of Washington, representing Ms. Perkins of Skagit County. 6/29, we have Mr. Peterson on behalf of Skagit County responds to motion to show cause, document number 6. Document number 7, 53-page declaration and exhibits of Gabrielle Clay, filed on 6/29. And then on 7/1, we have the petitioner's reply to respondent's response to show cause order. Mr. Hart, as far as you know, is that an accurate recitation of the record, sir?
Yes, the response included, in my understanding, my proposed order as well, but that may just be a technical thing to point out.
When you file a motion and proposed order, the proposed order doesn't go there. The proposed order has to, through the court administrator's office, go into a separate file. Do you have a proposed order for me so I can see that?
It was the last page of my response. It was the requested relief section.
Let's take a look.
I mean, titled it such.
Oh, is that where it says request for relief?
Yes.
Okay, well, that's not an order, that's a request, but that's okay. I can see what you're asking for then.
Yes.
All right. Anything else in the record, sir?
That sounds adequate.
Okay. Mr. Peterson, is that an accurate recitation of the record from your position?
Yes, it is, Your Honor.
All right. Mr. Peterson, you are representing Ms. Perkins on this. I have read the pleadings. Can you please briefly summarize your position?
Our position is basically this is an inappropriate challenge to past actions of the auditor and the Skagit County Canvassing Board. The challenge appears to be essentially a petition for writ of mandamus to compel the auditor to take certain actions which have already been done and does not need to be redone, and it actually was done at a public meeting, and therefore there's no basis for this court under the Open Public Meetings Act to engage in the quest for the petition for writ of mandamus to compel the auditor to act. And also I should note that the auditor office is setting a meeting for adoption of canvassing or an amendment of the Skagit County Canvassing Board rules for July 12th at 12:30 p.m. And notice will be published on that, my understanding, this weekend in the Skagit Valley Herald.
So that is under your analysis of page 6 where the show cause order is defective. That is your argument there, is that correct?
That's correct.
Further issues on this, because you've gone quite wide in your scope in responding other than this is just a writ of mandamus. Further expansion of your argument on that if necessary?
No, I don't believe further response is necessary. The problem with being able to respond to Mr. Hart's pleadings is that he does not clearly state what it was that he wants to have this court in as far as order, and it is difficult to create a response to such a nebulous pleading as he filed. And so given that circumstance, I tried to anticipate what the claims of Mr. part is actually pursuing so that we can move this forward and conclude the matter. And that's why I drafted the response the way I did.
In your proposed, in your response to the motion to show cause, you assert on page 10, line 6, 7, 8, petitioner provides no factual assertions or logical argument as to why inaccurate election results will occur at the August primaries. Can you please expand on that?
Well, there needs to be some claim, some establishment under the affidavit of elector statute that allows an elector to make a challenge that establishes there will be something that will be inappropriately done as a result of the lack of rules. For one, there are rules, and there are rules that Ms. Clay has indicated that they are operating under, which will guide the conduct of the elections. Those are going to be amended, as I said, and are likely to be amended at the meeting next week. But he enabled to establish an affidavit of elector that allows an election challenge. There has to be something that establishes that there will be some inappropriate conduct as a result, or inappropriate conduct of the election as a result. And there's nothing other than his saying, I believe it will happen. There's nothing that supports that.
Thank you. Anything further, Mr. Peterson, before we hear from the petitioner?
No, Your Honor.
Sir, I have read the pleadings. I've read Mr. Peterson's response. I read that in addition to your initial pleadings, your reply to respondent's response to show cause order. Is there anything else that you would like to add or clarify?
Absolutely, Your Honor, and just to make sure I read the court rules, is it 10 minutes is the time limit?
I've read everything in your file that you submitted. I've read everything that Mr. Peterson has submitted. That's the way that I like to proceed. If you're going to take time to write it, I'm going to take time to read it. And so I've done that in preparation. So is there anything you want to expand on or highlight in your pleadings? If so, proceed.
Okay, thank you, Judge. I think I'll highlight the whole argument from Mr. Peterson that it is without a passage, and that's my claim, without proper public meeting passage of administrative rules, there is no risk to the election system. I absolutely disagree with that, and the legislature disagrees with that as well. That's in law. They're not supposed to be following rules that haven't been publicly adopted to the process that should be adopted, and that's my claim. That was with my petition. I think it's important to clarify to the court the sequence of what's really happened here, because the sequence should add some perspective for you, Your Honor. 2005 was the year this process started. In that year, the legislature mandated that the auditor offices throughout the state adopt administrative rules in a public meeting format. The legislature was very clear in that requirement. RCW 43.30.010 emphasizes it and is referenced in it as the agencies and the tools which the legislature and the public create are not to operate independent of the public. That's the basic principle here. And that's what's been happening. 2005 was the year that the statutes were created in RCW 298.60.140. In 2019, 14 years after that, an audit, for lack of a better term, a review was performed. And that review, they evaluated 2019 elections and canvassing board actions here in Skagit County specifically, that included board members such as the Senator.
You say in 2019, there was an audit that they evaluated. Who's they that you were?
Correct, I did not state that. It was the Secretary of State's office at the direction of the legislature.
Okay, continue on, thank you.
Yes. They conducted a review, the 2019 Skagit County Election Procedures Review, that was included in Exhibit C of my pleadings, in which they evaluated, to my understanding, and the election system actions of that year. Those canvassing board members included Senator Perkins as the auditor, as well as Skagit County Commissioners Lisa Janicki and Ron Wiesen, and Deputy Prosecuting Attorneys Melinda Miller and Eric Peterson. The findings in that report were against them for a lack of compliance with public meeting law. And I think it's really important to understand that this has not been an isolated incident. This has a over a decade of non-compliance. And at that time, it was 14 years, and now we're in 2022. I pointed out that in page 5 of that report, and to clarify, the Skagit County Election Procedures Report of 2019 confirmed the canvassing board meetings were subject to public meeting law. They went on to say on page 6 of that report that Skagit County was deficient in its compliance, and they had no manual and never adopted one in accordance with public record law, public meeting law, excuse me. They also stated, and in their findings on page 12 of that report, the auditor had confirmed under her letterhead as the responding person to this report, and again, I emphasize that's very critical. The Skagit County auditor responded because she was the one identified by the Secretary of State Election Division as the responsible point of communication, that she was aware that they had not been complying with public meeting law in 2019. On page 13 of that same report, under the Skagit County auditor's letterhead, she affirmed with the Secretary of State, and because of their findings, that they would add and ensure that meeting minutes would be very clear, and it would include the statement, per motion by the Skagit County Canvassing Board, the following actions were taken. And she went on to ensure that public meeting law would be complied with in regards to specifically the section was for all meetings, but they were very pointed in the Canvassing Board manual. It was in this year that I found through my public records responses that were provided in Exhibit B of my pleadings, that the records request to the election office could not find a single notification stating there would be a public meeting for adoption of that manual, nor were there any public meeting minutes with any action taken or note of action had been taken for adoption of that manual. I'll also point out that the manual, and I believe that this should address something that was issued in the response by Mr. Peterson, that under the statutes, the Secretary of State had indicated that the manual adoption date had to be indicated under the adoption of the manual. Well, I will point out, because your judge, the Skagit County auditor and the responses have indicated a manual that was adopted. The only date on it is July of 2019. That is not possible. That is in violation of the manual adoption, along with the lack of minutes affirming they took action to adopt those and the lack of notification in any record. It has to be emphasized that the physical records are undisputed. In the response by the prosecuting attorney, there are no disputes that there are any physical records of adoption or public notifications of the manual compliance with public meeting law. And their own submittal to you, it shows further violation of a July adoption date that could not have happened. And that is very confusing to me as a member of the public. So I just want to make sure it's understood. This is a problem that's been going on with the canvassing board members, and unfortunately the public, and me as a member of this public, as a candidate in the upcoming election, Judge, I demand that the administrative rules be documented and adopted as the legislature requires in a public meeting. And that those meeting minutes, as the auditor had indicated to the Secretary of State she would do, there would be a record of the motion adopting them, none of which exists. As my request to this court indicated, there is a general distrust that this document was ever adopted under meeting law, and as the single most important and administrative policy for our election system, I will just be very clear. It is impossible for me to understand how a past canvassing board member or the auditor could dispute that the public meeting process should not be followed for adoption of our administrative rules. Unfortunately, I am here in front of the court because the past canvassing board members, prosecuting attorney's office, have refused to enforce public meeting law, and in contradiction to the legislature's intention that they not run this government without public involvement, they are continuing to do so and asking this court to permit it. My request to this court is to simply rely on the undisputed physical facts that there is no evidence and there is a concern and a preponderance of evidence proving that the manual was never adopted, administrative rules are not currently in place that were adopted using public meeting law, and that this court issue a formal statement stating as such that is within your powers to document this and stop this process from continuing. The auditor's office and the ongoing membership of the Canvassing Board manual have violated public meeting law that is undisputed. There are 17 years of it, undisputed. This court needs to affirm the public's right to have public meeting law followed and not to allow this process to go unaddressed and undocumented. That is my request of you and this court, Judge.
Thank you. The prosecutor alleges that in page 10, lines 4 through 8, petitioner, he says, additionally, the petitioner alleges that the claim lack of an open public meeting on the adoption of the rules, quote, will result in inaccurate election results in the upcoming election and also disenfranchises registered voters. That's your quote that he's referencing. He then adds, the petitioner, you, provides no factual assertions or logical argument as to why inaccurate election results will occur at the August primaries. And he is quite emphatic about that. How do you respond to the allegation that you've made no factual assertions or logical argument as to why inaccurate election results will supposedly occur in the August primaries?
I will approach that answer to two different perspectives. One is the administrative enforcement perspective. Without properly
Administrative what?
Enforcement.
Okay, thank you.
Without properly adopted administrative rules, there can be no enforcement of those rules. Thus, during the process, any process can be followed if there is not a legally adopted process in place. That in itself takes the teeth out of the administrative penalties that could be in place for violation of those rules, because again, they have not ever been legally adopted, so the people within them can state that they were following the rules as they understood them, because none were legally adopted. The second would be the actual rules themselves and holes within the rules. I can speak firsthand to that. These administrative rules that they are following have holes in their logic path for processing of certain parts of the election. One of which I will state is replacement ballot processing. There is no current administrative rule that requires the tabulation of replacement ballots individual to the reason that method is being, that ballot is being replaced. Again, I would provide this in a physical format to show this to you, so I'm just going to speak to it, and if you wish me to follow up with the physical records, I'm more than happy to do so. In 2020, there was physical records documenting categories of replacement ballots that included UOCAVA ballots, and they included other forms of replacement ballots. That documentation process allowed for the verification that there were ballots that had not been counted properly and had their votes destroyed, disenfranchising those voters who notably were overseas military voters. Following identification of that process, this auditor's office eliminated that process, eliminated the UOCAVA ballot categorization in their ballot duplication tracking. At this time, there is no record to be able for our canvassing board members to confirm the number of UOCAVA ballots that were duplicated. That administrative process disenfranchises voters. It disenfranchises those who have their votes taken away from the process. That would be one example.
All right, thank you. Anything else, sir?
Me or?
Yeah, you. I'm sorry. I want to make sure you got everything. You've been able to make your argument. And like I said, I've read the pleadings on both sides. So is there anything else before I hear again from Mr. Peterson?
There are 2 points I would like to make.
Okay.
The first of which I would just point out to you, Judge, that in response to my filing, there was a third-person hearsay statement given in affidavit format. I have scratched my head over and over trying to figure out what the level of information and should be relied upon in this court. And I'm speaking specifically.
I read your argument as to your reference to a quote third person hearsay statement.
Yeah, that doesn't even dispute, and it's such a significant point, because the members of the canvassing board, Eric Peterson, Melinda Miller, Lisa Janicki, Ron Wiesen, and Sandra Perkins, do not ever issue an affidavit argument against my statements. They are not willing to put under oath their own affirmation that I am wrong. I don't know how important that is to you, Judge, but to me and the rest of the public, it is a humongous void in their argument. Okay. So I would point that out to you, Judge, and also...
2 points. What was the second point?
The second point is I would really ask, Judge, for the situation to be acknowledged on the merit of how horrible this is for the public to find out that there are 17 years of violations. The case here is about 3 of them, and there's 14 years before that, of which no formal action by this court has ever happened. And the people that could initiate that are people who are actually defending what is happening here. That is significant, and I think I need to point that out to you in emphasis. Thank you.
Thank you. Mr. Peterson, anything further in response?
Just briefly, Your Honor, Ms. Clay indicates in her declaration that what was attached as the appendix, I believe it's Appendix E, to the canvassing board, to the FERC declaration, are the canvassing board rules signed by 3 members of the canvassing board, and are the rules which the canvassing board operates under. There appears to have been a scrivener's error by omission of the date of actual signature on it. We acknowledge that. That doesn't mean those are not the rules which the canvassing board operates under. Declaration of Clay at paragraph 10 on page 2 indicates those are the rules that the canvassing board has been operating under since they were adopted. So those are the rules, they're in place, and he has no evidence that disputes that those are not the rules in place. I have not provided a declaration. I wasn't at that meeting on November 26th of 2019. I didn't believe that the attendance of any members of the canvassing board are necessary. Ms. Perkins is available to come online if the court feels necessary to do that. But the petitioner is not even allowed to pursue this mandamus action, challenging what essentially is the claim that there was a failure to have a public notification of the particular minutes or particular agenda of the canvassing board meeting on November 26th of 2019. There was public notice of that meeting, which was a regular canvassing board meeting. Regular canvassing board meetings can include regular activity of that board, which would include adoption and modification of the rules. So he's not entitled to even pursue this action, because this is truly a mandamus action directed at apparently at the Skagit County auditor, in addition to the canvassing board individually to adopt rules. As I indicated before, we're going through the process of amending the rules, and a hearing is going to be heard on the Tuesday, July 12th at 12:30, where the amendment to the rules is going to be adopted. But but the petitioner has not established a basis that he's entitled to even pursue this action to compel this court to enter any order for the auditor to act.
Thank you.
Thank you.
Mr. Hart, final word, anything else, sir? This is your motion.
Yes, Your Honor. I'll point out again that the current rules, as they were presented, have a date of July. The date is required to be indicated on the rules. That is a violation of statute. And again, that is physical evidence provided by the respondent that they are in violation. There has been no evidence to dispute the evidence in front of you from me, and the public demands public meetings to adopt administrative rules in this election. Thank you.
Thank you. I'll note again the pleadings and evidence considered. Number 1, the affidavit declaration of Petitioner Cody Hart concerning alleged election improprieties and or omissions pursuant to various statutory references concerning the August primary election. The order on motion for order to show cause as the public notification of public meeting for adoption, filed on June 17. And the response from the state, filed on June 29. The declaration of Gabriella Clay, and then filed on June 29, and then the petitioner's reply filed on 7/1/22. This court makes the following findings. On June 14th, the petitioner filed an affidavit concerning claimed wrongful acts or omissions. He indicated he is a registered Skagit County voter. He indicates, quote, I personally identified that the current canvassing board manual has never been adopted with public notifications or in a public meeting as required by statute and WAC. And he references those particular RCWs and WAC. Then he said, I believe that the Skagit County Auditor's omission of both public notification and adoption of the Skagit County Canvassing Board election systems, administrative rules in a public meeting will result in inaccurate election results in the upcoming election and also disenfranchises registered voters. He contends in his pleadings that the Canvassing Board cannot certify the August 22 primary election until this issue is resolved. Further findings, the election supervisor, Gabriella Clay, filed a declaration indicating the Skagit County Auditor published notice of the meetings of the Canvassing Board for November 2019. Also, findings that Supervisor Clay stated the Skagit County Canvassing Board did adopt the Skagit County Canvassing Board administrative rules at a regular meeting of the board on November 26, 2019. This present act does constitute a mandamus action under 7.16.160 as argued by the state. This court finds that the petitioner has failed to establish the Skagit County Canvassing Board did not adopt the Skagit County Canvassing Board administrative rules at an open public meeting. The petitioner fails to establish that inaccurate election results will occur at the August primary. RCW 4230077 precludes this action. As a result, this action is dismissed with prejudice. Mr. Peterson, anything further?
No, Your Honor, thank you. No, Your Honor, thank you.
Mr. Hart, anything further?
Skagit County does not agree with you, Your Honor.
Sir, on the signature, I can indicate that you were present. I can have your signature. I can indicate you're approved as the form. What would you like on the signature page, sir?
You can indicate my name.
Okay. I'm going to have the clerk then indicate, so you can sign it as you wish, and she'll show you where your spot is. Thank you. Thank you. The copy is available at the clerk's office. That concludes our hearing. We are adjourned as to cause number 222460-29. Thank you all very much.